Mr. Coker's parenting time due to needing to provide some documentation on hair follicle testing, interlock paperwork. We set a status hearing for today. Counsel, what is the status of the case at this point? Ms. Henry, I'll address you first.
Yes, Judge. No documentation has been provided for the hair follicle test. I reached out to Christina Retzlaff, who is the domestic conciliator, to ask about the status of DC. She indicated to me that she's not heard from Mr. Coker, which would be contrary to what Mr. Coker had indicated at the last hearing, where he had set up some sort of payment plan with her and was planning to make payment. As far as she's reported to me, Mr. Coker has made no payment to her, and there has been no partial payment. So I do not believe that Mr. Coker was truthful to this court about that. I also don't have anything for a hair follicle test. As this court may recall, Mr. Coker indicated he had submitted to some sort of test on Rock Road hair testing or a drug testing facility. When we inquired, they didn't have any record of him. And then there's been no hair follicle test that has been received since that time. So I don't believe Mr. Coker was truthful with this court about that. I received just a minute or two before this hearing a documentation from Mr. Kidwell's office as it relates to the interlock device. I would note to the court, this is not the information that we requested from Mr. Coker. It shows an initial interlock install in April of 2023, and then there's some additional documentation from May. Our concern at the last hearing was that he had purchased a new vehicle after May and did not install the interlock device into that vehicle. Based on the information that's provided, it would appear that that is still the case. There is no documentation that has been provided for Mr. Coker that indicates that he has installed the interlock device in his new vehicle. So I still don't have that information that we've requested. Your Honor, you had indicated at the last hearing, if he fails to provide this documentation, his parenting time is reduced to Saturdays from 8 to 8. There has also been no child support that has been paid. And this is an issue that I wanted to bring up for the court. And I apologize, Judge, I'm just going to kind of go through my punch list if that's okay with Your Honor. I issued an income withholding order earlier this year because this court did order Mr. Coker to pay child support in 2022. I was contacted by Folston Siefkin after the last hearing because Mr. Coker has raised a legal issue with his employer about whether or not they can withhold wages, seeing as he's a subcontractor. So now his employer has had to engage in litigation services with Folston Siefkin to address Mr. Coker's concern. All the while, he has not paid 1 penny of child support to my client. Apparently, it is quite obvious that Mr. Coker doesn't believe the rules apply to him in this court. If he is this blatantly defiant of court orders, what's being done behind closed doors would be my question to the court. There are allegations he's made threats to kill my client, that he's called her a fat cow in front of the child. I think the court should assume that he has a positive hair follicle test at this point and is an active drug user because of his blatant failure to submit to a hair follicle test and produce that for this court for almost a year now. He's lied to this court about his communications with the domestic conciliator. He's lied to this court about his submission of a hair follicle test. He has not been truthful about the interlock device. My client would state that he is still driving Beckett around in a vehicle that we don't have any documentation has an interlock device installed in it. And so I think he's just thumbing his nose at this court. So for that reason, we're asking previously that his parenting time be reduced. That was our original proposed parenting plan back in July. We are renewing that request that his time be reduced even further. At a minimum, we're asking that it be reduced every other Saturday from noon to 8. Our original proposal was that it be supervised at VEP for 4 hours at dad's expense. So if the court wants to order that up to every other Saturday from noon to 8, I mean, we just don't believe that he is entitled to any additional parenting time, that it's in the best interest of Beckett to be around him for any additional parenting time, certainly no overnights, and that he should not be driving with Beckett at all. Because he has not produced any sort of documentation that would support that he is complying with other court orders as far as his interlock device. There is also an upcoming event on September 1st and 2nd. Mr. Coker has asked to take Beckett to a Red Sox game in Kansas City for his birthday. My client acknowledges that Beckett has been looking forward to this for some time. And in the best interest of Beckett, she doesn't want to prohibit him from being able to attend that, but she does not want Mr. Coker to transport him. So my client is willing to transport Beckett to Kansas City to attend the game, and then we'll pick him up after the game and drive him back home. And that should be Mr. Coker's parenting time for that weekend. I am also requesting fees at this point. We have had continuous review hearings for Mr. Coker's failure to comply with court orders. My client has incurred fees for preparation of those hearings, attendance of those hearings, and follow-up afterwards. We have had the last hearing because he didn't comply. We had this hearing to give him an opportunity to comply, and then we will inevitably have another hearing because Ms. Retzlaff indicates that she will have the DC recommendation next week. So given the cost that we have already incurred and future litigation costs and court costs that we anticipate having as a result of Mr. Coker's failure to comply with these court orders, we believe warrants an award of a prepayment of attorney's fees in the amount of $1,000 to my trust account. And Mr. Coker, I'd like the court to note, Mr. Coker is audibly laughing. I know that he's on mute, but as I'm making this argument, I can see Mr. Coker's face and he's laughing at what I'm arguing. So again, his thumbing his nose at this court and my argument and his blatant disrespect for the rules and what this court has ordered is apparent. And it's insulting to this court, to myself. It's not in the best interest of Beckett. He has not done anything that this court has asked for. And we did not have time to prepare a contempt prior to this hearing date, but Mr. Coker should expect that forthcoming because he has not done anything to show this court that he gives an iota of concern about his child. There are serious allegations that have been made against him, and he laughs in the face of those requests and fails to comply for anything. And so at this point, we continue to have significant safety concerns about Beckett while in Mr. Coker's care. And again, I would inquire to this court, if this is what he is doing so blatantly out and about, I can only imagine what is happening when we are not out in public, when we are behind closed doors and what is being said. Thank you.
Thank you, Ms. Henry. Mr. Kidwell, your response?
Thank you, Your Honor. The information that we received at 9:39 a.m. Regarding the vehicle, it was installed 4/18 on a 2001 Chevy Silverado, and the second piece of paper is confirmation of that, and it's on the same vehicle, and that's from the state of Kansas. So the reason I'm advising the court of that is that I believe that this is proof that that's not only did Smart Start install it, but the state verified it. And it also states on the piece of paper when he was supposed to bring it back in to check, there was an appointment in May. So to my knowledge, obviously this 2001 Chevy Silverado, and he's taken it back to Smart, it's the same vehicle. So I believe that of the list that was provided by Ms. Henry, that has been provided. I have not received hair follicle results. My staff contacted after the last hearing, Ms. Retzlaff's staff, and they advised that my client had contacted them and made payment arrangements, but I have not talked to them since we were here last. I do not have, as I stated, I don't have hair follicle information. All I have is the proof from the state and from Smart Start that there is an ignition interlock. I know that the income withholding order was being enforced. I was contacted by counsel for the corporation that Mr. Coker works for, and they had talked to the corporation, and the corporation said, yes, that's correct. So that income withholding order, my assumption, that was, I think, Wednesday. So I talked to Holly Dyer, and they went ahead and put the income withholding order in through his employer. As for the allegations of things that were said, allegedly said by my client, we talked about that obviously at the last hearing, and I don't have any information as to when and where these statements allegedly occurred, so I could obviously respond accordingly. I would like for Beckett to be able to go to the game, and if the court determines that Miss Ricky will drive the child up and bring the child back from the Kansas City baseball game, my only question is, and I will gladly do this for the court, if Miss Henry and the court ask, with these two pieces of paper, I can actually go and look inside the vehicle and see if the thing's working and make my client blow into it to see if it's working. But all this says is that he had it installed and he went back in May and it says check. So they check to make sure you haven't been driving, as you know, Your Honor, or attempted to operate the vehicle with alcohol.
Mr. Kidwell, it's been alleged that a new vehicle was purchased after May by Mr. Coker. Your response?
All I have is what was sent to my office, Your Honor, this morning at 9:39. And I'm assuming that this would be on a vehicle, meaning a new vehicle. But I don't have any other paperwork. And
I think what Ms. Henry alleged is that since the initial interlock was installed on that vehicle, that a different vehicle has been purchased or is being driven by Mr. Coker. Do you have any information in response to that allegation?
No, I don't. But if Mr. Coker would like to drive that vehicle to my office, I certainly know from all the criminal work that I do, Your Honor, how it works and what it's supposed to sound like. And it should be on the vehicle that he stated to the court is the vehicle he's driving. That has been his statement.
Ms. Henry, did I properly identify what your allegation was in that regard?
Yes, Your Honor.
Okay. All right, go ahead, Mr. Kidwell.
I understand that Ms. Henry stated that she'll be filing a contempt, and that she is seeking $1,000 in fees. Obviously, that is the court's decision solely as for how that goes. In the contempt, I know that because we plead with such specificity, I can properly respond. So I would only ask that the issue of attorney's fees be held until we have the contempt hearing. But going back to that vehicle, as I said, if the court would like, I'm an officer of the court. If he drives a vehicle here, we can take a picture of the VIN number and a picture of the ignition interlock and the vehicle itself, and I can send those to Miss Henry. But as I stated, the only thing I have was what was received at 9:39.
All right, anything further, Mr. Kidwell?
No, I just confirming that I do not have a hair follicle. When my staff contacted Miss Retzlaff, my office manager talked to one of her assistants. They stated that he had started a payment plan, so we have not called back. But I think the child support order, now that the income withholding order was actually filed with the corporation through outside counsel, as I stated, Miss Dyer contacted me. So that obviously is being withheld. I don't know when that first payment will show up, but that was, I'm guessing it was Tuesday or Wednesday I spoke to Miss Dyer, Holly Dyer. So I'm still waiting for a hair follicle, and obviously we can recontact Miss Retzlaff. But the issue of the child support not being paid has been corrected because they did issue that income withholding order that you ordered last year.
I'm looking back through my docket notes, and I don't know if this is the first time that I ordered it, but back on November 14th, 2022, at that time, each party was ordered to do a hair follicle test. We still don't have a hair follicle test from your client, Mr. Kidwell.
That's correct.
And the only assumption that the court can make by someone refusing to provide a hair follicle test is that it's going to be dirty. We've had a number of excuses. Oh, I didn't have a driver's license, so I could go get it. We don't have any child support paid. We've had an income withholding order on file. Mr. Coker has been advised that if a income withholding order is not paying out, that it's his responsibility to make the child support obligation. That hasn't been done. We don't have a domestic conciliation report or any proof that payments have been made by him towards that. Mr. Coker's doing absolutely nothing to further his position in this case. It's baffling to me. Because Mr. Coker, in this court's mind, is using illegal drugs and or alcohol, I'm going to modify his parenting time to every other Saturday, supervised with VEP for up to 4 hours. The first Saturday can be this Saturday, tomorrow. Regarding the Red Sox game, I'm going to adopt the recommendation from Ms. Henry that Ms. Ricky transport Beckett to the game and drive him back after the game. Mr. Kidwell, you've offered to have Mr. Coker drive the vehicle to your office. Frankly, I'd appreciate if he would do that. I have no confidence that he will actually follow through and do that, because he's followed through on absolutely nothing up to this point that's been asked of him to do. But if you can do that and provide the information to the court would take that into further consideration down the road. Regarding attorney's fees, I'm not going to order those at this point, though I will reconsider that down the road. I'm not going to set a further hearing at this point. If domestic conciliation recommendations are made, you all can follow the appropriate local rule regarding either adopting those or by agreement, or scheduling a hearing if there's objections. If Ms. Henry, you do file a contempt motion, we can get a date to take that up, but I'm not inclined to set another date, because frankly, we're not accomplishing anything each time we show up. So,
Your Honor, would it, as I explained, I could do that because I've had to do it in other municipal and state courts. And what I normally do is take a picture of the VIN through the windshield or on the door, and then I take a picture of the device, and then I have my client start the vehicle, and I take a picture of the vehicle running with the device after they blow in it.
that would certainly, if that's able to be accomplished.
I can do that whenever he can bring it by.
Regarding that issue. But again, that's not going to alter the order that's been made here today.
I understand, Your Honor. I just wanted to be specific because I've had to do it before for over the years for different clients.
Very well. Ms. Henry, anything further or need clarifications from your end?
2 questions, Your Honor. The first, I just want to make sure the record is clear. We acknowledge that he has a Chevy Silverado that likely has an airlock device in it. The concern is that he has purchased he's purchased another Chevy Silverado, so same type of vehicle, but that vehicle does not have an airlock device in it. So while I appreciate Mr. Kidwell's offer, and certainly if he wants to do that, that's fine, but we're not disputing that there is a vehicle with an interlock device in it. The concern is there is an additional vehicle that Mr. Coker has been transporting the child in after May that does not have an interlock device in it. So if Mr. Coker brings one vehicle to Mr. Kidwell's office to verify that's an interlock device, unfortunately, that's not going to alleviate the concern we have that there is another vehicle out there, same make and model, that Mr. Coker has purchased and is transporting the child with that does not have an interlock device in it. So that was one thing I wanted to make clear. The second is I would ask that the VEP be at Mr. Coker's expense, especially since he is so far behind in child support. And my client, honestly, we just don't have the additional funds to pay for supervised visits. And this is all because of Mr. Coker's failure to comply with court orders. So we believe the onus should be on him to be responsible for that financial burden.
That will be the order of the court.
Thank you.
All right, anything further, Mr. Kidwell?
No, Your Honor.
All right, Miss Henry, can I task you with preparing a journal entry reflecting the orders the court has made here today?
Yes.
All right, if there's nothing further, we'll be in recess. Thank you.